Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast number 60. This week we're looking at three cases covering a range of employment topics. The first of them deals with disability discrimination and the duty to make reasonable adjustments. The second case looks at whether the costs of in-house legal representation can be recovered under the Tribunal rules related to costs. And the final case concerns a harassment claim in the context of a TUPE transfer, and, in particular, the relevant time limits and the correct comparators for such a claim. Finally, as a reward for sticking with me to the end, I've got a recommendation for a podcast. So, first case, General Dynamics, Information Technology and Carranza. This is an EAT decision dealing with an appeal by General Dynamics against an employment tribunal decision which found that they discriminated against Mr. Carranza on the basis of disability and that they'd unfairly dismissed him. By way of a brief summary, the law concerning the duty to make reasonable adjustments can be found at Section 39(5) of the Equality Act 2010. Failure to comply with this duty will result in a determination of unlawful discrimination under Section 21(2) of the Equality Act. Under the Equality Act, where an employer's provision, criterion or practice, PCP, puts a disabled person at a substantial disadvantage in comparison with those who are not disabled, that employer must take such steps as it is reasonable to take to avoid any such disadvantage. The law related to unfair dismissal provides an employer must show it has a fair reason for the dismissal, and in the circumstances the employer acted reasonably in treating that particular reason as a sufficient justification to warrant dismissal. Facts of the case were Mr. Carranza was employed by the London Borough of Lambeth as a customer services advisor in 2008. At the end of December 2011, he was TUPE transferred to General Dynamics. It's not in contention that he had a disability for the purpose of the Equality Act, because he suffered from stomach adhesions as a result of an emergency operation to remove a ruptured appendix. Accordingly, London Borough of Lambeth, while it was his employer before the TUPE transfer, made adjustments, including him time for extra breaks, and he had time off to attend medical appointments. Under Lambeth Borough's sickness policy, there was a trigger level at which formal action would be considered. It's triggered if an employee takes 4 periods of sickness or a total of 10 days' sickness in any 12-month period. Any disability-related sickness is disregarded for the purpose of assessing whether the trigger for the formal action has been reached, although disability-related sickness could be taken into account once the trigger level had been met. Mr. Carranza had taken enough non-disability-related sickness to trigger the formal procedure under the sickness policy. As a result, he got a written warning from Lambeth. Before the TUPE transfer, he had then taken further substantial long periods of time off work, something like 41 weeks in the last 3 years. Accordingly, in September 2011, 3 months before the TUPE transfer, he got a final written warning to remain in force for 24 months. In the final written warning, it was highlighted that he had also not complied with the correct policy when taking the time off. Also, reasonable adjustments had been made, there was already a written warning on the system for sickness absence, and his time off was having a substantial impact on the business, it was said. Well, December 2011, he transfers across to General Dynamics under TUPE. By virtue of TUPE, all his rights and liabilities came across with him, which meant the final written warning continued to apply to him. Following this, he had 2 further short periods of absence which were related to his disability, which didn't result in any further action by General Dynamics. He was then subsequently absent for 3 months as a result of a shoulder injury. It was agreed, and this was important, that the injury was not a disability. When Mr. Carranza returned to work, General Dynamics took advice from Occupational Health and went into a formal disciplinary procedure. He was invited to a hearing, following which he was dismissed, and his appeal wasn't upheld. It's noteworthy, if refreshingly honest, that at the original disciplinary hearing, Mr. Carranza accepted that he too would have dismissed himself if the decision had been his to make. Well, obviously there's a bit of a change of heart there because he brought a claim in the Employment Tribunal. And as I mentioned, it was accepted that he had a disability due to his stomach adhesions, but he did not have a disability in respect of the bad shoulder that had led to his termination. Key question before the Employment Tribunal was whether the failure to disregard his sickness absence for his stomach adhesions, the disability-related ones, amounted to a failure to make reasonable adjustments when he was dismissed. The majority of the Employment Tribunal considered that General Dynamics had failed to make reasonable adjustments as they had not discounted all disability-related absence when considering the final written warning on file. The Employment Tribunal also decided that the dismissal was unfair for two reasons. First, they said the company had acted in an unlawful manner in respect to the discrimination by reason of failure to make reasonable adjustments, and alternatively, they had failed to review the final written warning, and so the employer had not acted reasonably, because a reasonable employer would have considered the non-disability shoulder injury in context before considering the sanction. So the dismissal was procedurally unfair, and the tribunal went on to consider a Polkey reduction. When the case went to the EAT, it overturned the Employment Tribunal findings on both counts and decided the matter was sufficiently clear. They didn't need to send it back to the Employment Tribunal. They decided there was no unfair dismissal or disability discrimination. The EAT held that when considering disability discrimination and the duty on the employer to make reasonable adjustments, the tribunal had to first identify the employer's PCP. Secondly, it had to identify comparable persons without any disabilities. And thirdly, consider the nature and extent of any substantial disadvantage suffered by the disabled employee. The EAT said that only then could the tribunal go on to find out what steps are reasonable for an employer to take to avoid the disadvantage. The EAT placed emphasis on the fact these are actual steps which are required, which means more than merely a mental process or a mental assessment. It requires practical actions, practical steps by the employer. Here, it was determined that the PCP was the requirement for consistent attendance at work, and the EAT accepted that was the correct PCP to consider. It was the practice of attending work regularly which was causing the claimant a disadvantage in view of his disability. However, the EAT then found that the tribunal had not identified the step which it was reasonable for the respondent to be required to take. The only step which could be identified by the EAT was the disregarding of the final warning, and the EAT said they doubted that disregarding a final warning could count as a step for the purposes of 20(3) of the Equality Act. The EAT went on to note that formally revoking a final written warning might count as a step, but merely the mental process of disregarding a final written warning was not what was contemplated by the legislation. The Employment Tribunal found that because the first two short-term disability absences post-TUPE were disregarded by General Dynamics, this had been further evidence as to why the final written warning should be disregarded. The EAT really didn't agree with that approach, and they said it would be, quote, remarkable and regrettable if an employer who'd shown leniency to a disabled employee in the past became required by law to disregard all disability-related absences, whatever the impact on the business. The EAT concluded that the findings of the Employment Tribunal majority could not stand because they didn't identify a valid step for the employer to take to make the reasonable adjustments, and there was no substantial basis for finding that the disregarding of a final written warning was a reasonable step for General Dynamics to take in any event. So, pausing there, before I go on to deal with the unfair dismissal claim, I think the case is a useful one and provides helpful guidance for employers and employees alike. The EAT, at the end of its decision, commented that in its view the claim was not one which really worked as a reasonable adjustments case. The EAT commented it might have been easier to brought a claim like this one, or to view a future claim such as this one, as being one of discrimination arising from disability, rather than one which was to do with a reasonable adjustment. As mentioned above, the reasonable adjustment duty applies according to section 20(3), where a PCP, provision, criterion or practice, puts a disabled person at a substantial disadvantage in relation to people who are not disabled, meaning the employer has to take such steps as it is reasonable to take to avoid the disadvantage. On the other hand, discrimination arising from disability is within section 15 of the Equality Act, and this applies where an employer treats the employee unfavourably because of something arising in consequence of the employee's disability, and the employer cannot show that the treatment is a proportionate means of achieving a legitimate aim. The EAT summarised this as section 15, disability arising. Section 15 is focused upon making allowances for disability and unfair treatment because of something arising in consequence of disability, and this is prohibited conduct unless it is a proportionate means of achieving a legitimate aim. On the other hand, the reasonable adjustments provisions focus on affirmative action. If it is reasonable to do so, the employer will have to take steps to avoid substantial disadvantage. Naturally, sometimes the two forms of unlawful discrimination will be closely related, but in cases for poor attendance and dismissal for poor attendance, it's difficult to analyse this as a reasonable adjustments case. I think on this basis, employers should be prepared to justify dismissals on the grounds of absence, connected in some way with the disability, as a question of whether they could be guilty of discrimination arising from disability. The EAT, however, considered whether the claimant would have been better placed in this case if he had made such an argument, i.e. brought it as a claim of discrimination arising from disability. But the EAT thought this was not a case about taking practical steps to prevent a disadvantage. It was a case about the extent to which the employer was obliged to make allowances for a person's disability which, with the greatest of respect, entirely fits with the realities of the situation. The EAT commented that if the case had been put that way, i.e. discrimination arising from disability, it would have been doomed to failure. It was legitimate for the employer to ask for consistent attendance at work, and the carefully considered final written warning was plainly a proportionate means of achieving a legitimate aim. It was really unarguable, in the view of the court, that dismissal after a further very substantial absence was not a proportionate means of achieving a legitimate aim. The EAT went on to consider the unfair dismissal claims, and with regard to the failure of the employer to review the final written warning and the reasons for it, the EAT decided that the Employment Tribunal had erred in law. In reaching that decision, the EAT applied the Court of Appeal's test in relation to dismissals for misconduct. And the Court of Appeal had laid down previously that the test was whether it was reasonable for the employer, given all the circumstances, including any previous written warnings, to dismiss the employee. It's not for the tribunal to reopen the written warnings. Rather, it is for the tribunal to determine whether the employer could have reasonably taken the warning into account in deciding whether to dismiss. In making that assessment, it is relevant to consider issues of good faith, whether on the face of it the grounds for giving the warning are reasonable, and whether it was manifestly inappropriate to issue the warning. The EAT decided that, although this test had been applied in a misconduct case, it applied equally here in relation to other types of dismissal. And here, it was appropriate to limit the extent to which an employer was expected to revisit an earlier stage in the proceedings. And as the final written warning was not issued in bad faith, and it met the other tests of the Court of Appeal case, this part of the case could not stand. The employer had not been under duty to review the final written warning. Moreover, it was quite clear the final written warning had been carefully reasoned, and the explanations had been sent out to the employee. Therefore, the Employment Tribunal erred in law in believing that General Dynamics required, in whole or in part, to discount the final written warning, and his unfair dismissal claim, too, was not successful. Okay, so that's General Dynamics and Carranza, and the key points are the dismissal for ill health absence was neither a breach of a duty to make reasonable adjustments, nor would it have been discrimination arising for disability, and it also shows the court continuing the trend of not wanting to open earlier final written warnings, which are then taken into account in dismissal, unless there are specific grounds for doing so, such as the original warning being issued in bad faith. So the next case is Laddak and DRC Locums Limited. In summary, this is an EAT case involving a disagreement as to the meaning of costs in the Employment Tribunal Rules of Procedure. The main argument centred around whether DRC Locums, which used an in-house legal representative to fight its case, was able to recover the costs of that in-house legal service. As a way of brief background, Mr. Laddak had been employed by DRC Locums for a number of years. However, on 12th of August 2011, he brought a claim for unfair dismissal and discrimination on the grounds of religion and belief. A hearing was scheduled for January 2012, and the discrimination claims were then struck out. At that hearing, case management directions were given in relation to the unfair dismissal claim. Mr. Laddak subsequently failed to comply with those directions. As a result, DRC Locums applied for the unfair dismissal claim to be struck out shortly before the full hearing. Following this application, the Employment Tribunal wrote to Mr. Laddak to explain that the claim will be struck out unless the objection had been in writing within 7 days. Mr. Laddak failed to respond. Unsurprisingly, the claim was struck out. And DRC Locums put forward that by the time the claim was struck out, it had already undertaken substantial work in preparation for the trial, and therefore it had built up considerable in-house legal fees, which, guess what, it wanted Mr. Laddak to pay. Well, it didn't take long for the tribunal judge to decide that Mr. Ladak's behaviour crossed the threshold for an award of costs made against him, and this wasn't disputed by the time the matter came round to appeal. In essence, the appeal centred around whether the definition of costs under Rule 38.3 of the Employment Tribunal's Rules of Procedure 2004 and the equivalent Rule 74.1 in the 2013 rules covers in-house legal expenses. Mr. Ladak argued that the definition of costs that's used in those rules, which is fees, charges, disbursements or expenses incurred by or on behalf of a party, unquote, is not wide enough to cover the costs or the time spent by in-house legal representatives. Mr. Ladak put forward a technical argument based on the definition of costs, which he said was different under the CPR from the Employment Tribunal rules. He tried to draw a distinction between a civil litigation claim, where the costs of an in-house legal representative would be covered, and an employment litigation claim, where, he asserted, such costs would not be covered. He argued that under the civil procedure rules, the words remuneration was used as well as the words fees, charges, disbursements or expenses, and therefore the definition was wider. DRC locums argued it had been quite remarkable if the costs of the in-house legal representatives were not recoverable. Moreover, there's no reason to suppose that the 2004 rules or the 2013 rules were ever intended to change the long-standing position. Well, the AT said there's never been a definition of costs previously and in the primary legislation. Detailed provisions had always been included in the rules of procedure, and prior to 2004, the rules themselves did not contain any definition of costs. Therefore, in the case of Wiggins, the court had to decide whether to award costs to an in-house legal department, and it decided that it did have the power to award such costs. As a result of that decision, it has been clear that the costs incurred by in-house lawyers are as much recoverable as the costs of independent employed solicitors. Therefore, following the long-standing approach and supported by the court in Wiggins, the AT found there was no reason to doubt the correctness of that decision or to depart from it. Fees were recoverable. The AT highlighted that there would be a remarkable gap in the rules if the position put forward by Mr. Ladak was correct. It would seem odd if external legal counsel were able to claim all their costs, but a party represented by in-house legal counsel was unable to claim any significant amount of costs. Indeed, an employer with an in-house lawyer representing them would otherwise be at a double disadvantage, because parties who are representing themselves can claim preparation time for hearings. This is designed for those who are not legally representative, and so would not be available for an employer using an in-house lawyer. But on the other hand, if Mr. Ladak's arguments were right, the employer would not be able to use preparation time, and on the other hand, it wouldn't be able to claim costs and expenses because that was outside of the scope of their ambit. To the judge's mind, and surely also to anyone else's mind, it's relatively clear and plain from the words that they're not to be read restrictively, but they're to be read in the normal language of the situation. It seems clear that there had been no parliamentary intent to move away from the position laid down in Wiggins, and the AT noted that if Parliament had had any desire to achieve a particular outcome, this would have been made crystal clear in the legislation. Therefore, the AT was able to dismiss Mr. Ladak's claims. Rule 38.3 does not place any artificial restriction on claims for recovery of costs, but helpfully, the judge also went on to mention that the 2013 rules of procedure don't depart in any way from this protection. The case is a useful summary of case law in connection with in-house legal costs. It's a welcome decision for employers who have large in-house legal resources and would not want to be forced to use external legal representatives in some cases. It's hard to disagree with the AT when they say that there would be a remarkable gap if in-house legal costs were not recoverable, but external legal costs would. This would seem to draw a rather arbitrary distinction between the types of legal representation used, rather than a meaningful distinction as to the nature of costs that we encountered. Clearly, then, it's a separate issue as to how in-house legal teams will capture time and costs designed to form the basis of any assessment of cost awards to be made to the Employment Tribunal. Remember as well that the Employment Tribunal, since 2013, have the power to award summary costs up to £20,000, or to take a detailed assessment of costs in accordance with the CPR rules and procedures, up to any amount. In other words, it's no longer necessary to go to the county court if you are seeking to recover more than £20,000. So that's the case of Ladak and DRC locums. Third and final case, Vernon and Azure Support Services Limited and others. It's an EAT decision which looks at time limits under which to bring a claim in respect of sexual harassment. in the context of a TUPE transfer. The judgment also looks at who the correct comparator should be where there's been a dismissal in these circumstances. It's a good illustration of the interplay between TUPE and discrimination law, and makes some interesting comments about the comparator in a case where two individuals are having a consensual relationship and the employer then terminates the employment of one of them. The facts of the case where the employee, Ms. Vernon, was employed by Port Vale Football Club as their sales manager for events. In July 2011, the catering function of the football club transferred to Azure. Ms. Vernon's employment therefore transferred to Azure under TUPE. Port Vale Football Club, so that's the transferor, Azure the transferee. Ms. Vernon was employed by Azure until her dismissal 3 months later in October 2011. Before and after the transfer, Ms. Vernon was subjected to what the tribunal found to be acts of sexual harassment by the unfortunately named Mr. Bedding. Mr. Bedding was employed throughout by Port Vale and he did not transfer to Azure. That's quite important. So, Azure required its employees not to have any personal relationships with Port Vale's football players. However, Ms. Vernon apparently did have some sort of relationship with one of the football players, although I should make it clear that the case report is not specific about what this actually encompassed, and Azure itself didn't come to any final conclusions about that when she was dismissed. As a result of the disclosure that there had been some sort of relationship, Ms. Vernon ended up being subjected to the disciplinary proceedings, and it was claimed, and then determined by Azure, that she had broken the duty of mutual trust and confidence, and had jeopardised Azure's contract with Port Vale. She was dismissed following the disciplinary procedure. Ms. Vernon brought numerous claims before the Employment Tribunal, including direct and indirect sex discrimination and sexual harassment. Well, Tribunal found that the dismissal by Azure, the transferee, was an act of direct sex discrimination, as if Ms. Vernon had been a man, Azure would not have dismissed her for the reasons they did. The hypothetical comparator used was that of a heterosexual man having a relationship. Secondly, the Employment Tribunal held that Port Vale, transferor, was vicariously liable for the acts of Mr. Bedding, because it employed him, when he subjected Ms. Vernon to harassment. However, as Mr. Bedding remained at Port Vale, whereas Ms. Vernon had transferred to Azure, Azure could not be liable for any acts of harassment by Mr. Bedding that occurred after the transfer date. He was no longer in common employment with her, and therefore Azure, who'd never employed Mr. Bedding, couldn't be vicariously liable for his actions. However, the Employment Tribunal did not consider that Port Vale's vicarious liability for the harassment transferred under TUPE to Azure. So, not surprisingly, both Ms. Vernon and Azure appealed to the AT. Ms. Vernon appealed on the grounds that Port Vale's vicarious liability did not transfer to Azure, and that the finding by the tribunal was clearly wrong. It should have transferred. Azure appealed on the basis there was no sex discrimination in connection with the dismissal, and therefore its actions should not result in legal liability against it. The AT allowed Ms. Vernon's appeal and dismissed the appeal by Azure. Well, at the beginning of the hearing, Azure accepted that the historic vicarious liability which was incurred by Port Vale, the transferor, in respect to Mr. Bedding's actions, was transferred to the transferee, Azure, under TUPE as a matter of law. So, in respect of actions occurring prior to the date of TUPE transfer, the historic vicarious liability comes over. However, the transfer had taken place in July 2011, her dismissal by Azure took place in October 2011, and she hadn't put in a tribunal claim until December 2011. So she had put in her tribunal claim within 3 months of the date of her dismissal and the last incident of harassment. However, she was now more than 3 months after the date of transfer. Not surprisingly, the transferee said, 1. We're not liable for Mr. Bedding's actions after the date of transfer because he never was our employee. Well, fair enough. Therefore, the transferee said, if we're liable to inherit liability for his actions before the transfer, because of vicarious liability and TUPE combined, then that liability had to have come to an end in July 2011. Therefore, the claim was out of time. Ms. Vernon contended, 1, the claim was within time. She had, as a matter of fact, continued to be harassed by Mr. Bedding, and so there was a continuing course of conduct which continued up to within 3 months of her putting in the claim. The fact that Mr. Bedding was no longer an employee working for the same employer as her did not prevent there from being a continuing course of conduct. And 2, it would be just and equitable to extend the time. DAT agreed that for the purpose of bringing the claim, the timing issue, the course of conduct had continued and therefore the claim was brought within time. And in any event, the EAT's decision was that it was within the possibilities, it was within the scope for the tribunal to say that it would be just and equitable to extend time for a claim in any event. So either way, the claim was within time. Well, just looking at this aspect, it's clearly a fairly specific set of facts. The individual went through a TUPE transfer, but was still working in sufficiently close proximity to her harasser for her harasser to be able to continue to inflict acts of harassment on her. Well, notwithstanding that, it's still a slightly curious outcome. The claims were within time, even though the legal status of those acts of harassment changed following the transfer, because Azure was no longer directly, vicariously liable for them. Nonetheless, there was a factually continuing course of conduct, and therefore that was sufficient to enable the claims to be held to be within time. So that left the second issue, the big issue as well, as to the issue of the comparator. Well, the EAT emphasised that the circumstances surrounding the hypothetical comparator had to be sufficiently similar to the circumstances of the employee in question, except in relation to gender. Here, therefore, in circumstances where the woman was dismissed for being in a non-approved relationship, let's call it that, but the male employee was not dismissed, then it was open to the employment tribunal to construct a hypothetical comparator of possibly a hypothetical homosexual male in a relationship with a homosexual footballer, or a hypothetical heterosexual male in a relationship with a heterosexual female footballer, so long as it's sufficiently clear that the distinction is that of gender. The EAT had decided the tribunal had taken into account, one, the fact that there had been no action taken against the footballer in the relationship, and two, they had decided that a man in a comparable situation would not have been treated the same way by Azure as Miss Vernon had been treated by Azure. It was key as well to the tribunal's findings that the owner and operator of Port Vale Football Club continued to be closely involved in the management of Azure. The reason that's important, of course, is that Azure itself had no ability to dismiss the footballer, but once it was looked as a matter of joint, effectively, decision-making or joint input, then the failure to dismiss the footballer, of course, is highly relevant. The tribunal found that the club was clearly behind both the suspension and was involved in the dismissal. I think it's helpful the judge took a, frankly, pretty holistic view as to the issue of the comparator rather than getting unnecessarily caught up in whether the comparator had to be a homosexual or a heterosexual individual. The approach taken by the EAT certainly seems sensible in that as long as the key differential is gender between the actual individual and the hypothetical comparator and the other circumstances are sufficiently similar, that enables a valid comparison to be made. So even though the EAT spent quite a lot of time on this point, they ultimately decided that focusing on the specifics of the comparator wasn't actually that helpful, and the tribunal really needed to focus on the key question as to the reason why the employee was dismissed and whether that reason was based on the grounds of sex. These cases do come up quite often against the background of where there is an admitted relationship rather than circumstances here where the truth of the matter is rather less clear-cut. Nonetheless, it's important for an employer to know how a tribunal will compare its treatment of the employee who's being asked to move on. Considerably more often than not, if I can put it that way, it's the female employee that's asked to move on, often on the grounds that they are the junior employee in the relationship. Knowing whether this is going to be tested for discrimination purposes against the hypothetical treatment of a homosexual employee, or if the genders were reversed, then the more junior male employee would be dismissed. It's absolutely critical for employers to know this when considering whether it's safe to move an employee along if there's been a relationship contrary to company policy, if that is what the employer wants to do. So, thank you very much for listening to that. I said I would end with just a few words about a podcast recommendation. And for those of you who haven't yet come across the series, can I strongly recommend the podcast Serial, as in Serial, rather than the breakfast stuff. It is, I think, the top-rated podcast, American podcasts. It's an amazing true life. It's billed as a true life story connected with a murder trial that took place 15 years ago, where they go through the evidence, you hear the court witnesses in court, you have interviews with people caught up in the case, and so on. And it is absolutely gripping, and it certainly has your sympathies swinging back one way or another as you listen to it. So if you're not listening to Serial, as long as you continue to listen to this podcast, take on board Serial as well. Thanks very much for listening. Bye.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.